Bizarre Law Files. Episode 1, Animals on Trial. Cold Open. Somewhere in Normandy, France, in the autumn of 1386, a creature was removed from a prison cell and prepared for public execution. It had been held in custody for several weeks, fed, guarded, kept alive specifically for this moment. Before it was taken to the gallows, attendants dressed it in clothing, a jacket cut and fitted to its body, gloves placed on its front limbs, breeches, a cap. It was then walked through the streets of the town of Falaise, in front of a crowd that had gathered for the occasion, to a public gallows that had been erected in the town square. The sentence was carried out. The executed was a pig, and every single person who watched it happen believed, without doubt or irony, that justice had been served. ACT1, the legal world that made this possible. Before you can understand how a pig came to stand trial in a court of law, you need to understand the world that court existed in. Not because the people were foolish, not because the institutions were primitive, but because the foundational premise of medieval European law was so different from what we practice today that it might as well belong to a different species of civilization altogether. Today, we understand the law as a system designed to regulate human behavior. Human beings have rights. Human beings have responsibilities. When those responsibilities are violated, the law intervenes. Animals exist outside this framework entirely. They cannot be guilty. They cannot be innocent. They are, in legal terms, objects' property, not participants. This was not always the case. For the better part of 1,000 years, across most of Western Europe, the law operated on a fundamentally different philosophical foundation, one that did not draw a sharp line between human beings and the rest of creation. That foundation was theological. Medieval legal philosophy held that God had established an order over all of creation, not just over human society, over everything. The crops, the rivers, the seasons, the animals in the field, the insects in the earth. All of it existed within a moral architecture that God had designed and that human institutions, including the courts, were obligated to uphold and enforce. Under this understanding, the law was not merely a human agreement. It was a reflection of divine will, and divine will extended over everything that existed. Which meant that when something disrupted that order, when something violated the moral framework of creation, the law had not just the right, but the sacred duty to respond. An animal that killed a person had not simply caused an accident. In the eyes of a medieval ecclesiastical court, it had committed an offense against the divine order. It had disrupted the hierarchy of creation. And the law, as the instrument of divine authority on earth, was required to answer that disruption. This was written down, argued, codified, passed between legal scholars in correspondence, and published in treatises that circulated across European universities. It was not fringe thinking. It was not the belief of isolated communities. It was mainstream jurisprudence, practiced from France to Germany, from Italy to Switzerland, from Canada to the early American colonies. And it produced something that, to the modern eye, looks completely impossible. It produced animal trials. Historians have now documented more than 200 cases in which animals were formally charged, prosecuted, and tried before courts of law across Europe between the 9th and 18th centuries. The defendants were not exotic. Pigs were the most common, accounting for the majority of documented cases, most often for attacks on children. But the dockets also included horses, cows, dogs, mules, eels, dolphins, locusts, weevils, flies, caterpillars, and rats. Each case followed the established procedures of whatever court held jurisdiction. Charges were formally filed. Evidence was gathered. In cases where the defendant was considered capable of a criminal act, a defense lawyer was sometimes appointed. Verdicts were reached. Sentences were handed down. Some defendants were convicted and executed. Some were acquitted on insufficient evidence. Some cases were thrown out on procedural technicalities. One case resulted in a formal land settlement. These were not carnival proceedings. They were not village mob justice dressed up in legal language. They were serious, documented, legally binding proceedings conducted by trained professionals who took them as seriously as any other matter before the court. The records they left behind, court documents, municipal accounts, legal commentaries, church archives, are not records of ignorance. They are records of a civilization that believed, completely and without reservation, that what it was doing was right. That belief produced 3 cases that history has never fully been able to leave alone. We begin in Normandy. Case 1, the Pig of Falaise, 1386. The town of Falaise sits in the rolling countryside of Normandy, in what is now northern France. In 1386, it was a prosperous market town, home to craftsmen, farmers, merchants, and the administrative apparatus of Norman civil authority. It was also home, on the outskirts of town, to a sow. In the late summer or early autumn of that year, the exact date is not recorded, the sow escaped from her enclosure. She made her way into a nearby dwelling. Inside, she found an unattended infant. The child died from the injuries it received. The sow was captured and brought to the attention of the civil authorities. A formal complaint was lodged. The matter was referred to the local court. What happened next was not a summary execution. It was not a farmer killing the animal in revenge. It was a trial, a full, procedurally correct, legally binding trial, conducted according to the established norms of Norman civil law. The sow was placed in a cell. A jailer was assigned to her care and compensated for his time. The court established a timeline for the proceedings. Witnesses were identified, people who had been in the vicinity of the dwelling, who could testify to what they had seen. Their accounts were gathered and reviewed. The question before the court was not simply whether the sow had caused the child's death. That was not in dispute. The question was whether she bore criminal responsibility for it, whether she could, under the legal framework of the time, be held morally accountable for her act. The court determined that she could. The verdict was guilty. The sentence was death by public hanging, to be carried out in the main square of Falaise before a gathered crowd. But the court went further. The sentence included a provision that has made this case one of the most studied in the entire history of animal trials. Before the execution, the sow was to be dressed in human clothing. The municipal accounts of Falaise for the year 1386, accounts that survive in the historical record to this day, itemized the expenses associated with the case. The jailer's daily fee for maintaining the prisoner, the cost of the rope, and then carefully noted alongside the other court expenses the cost of a pair of gloves, the cost of a man's jacket altered to fit the animal's body, the cost of breeches. These were not symbolic gestures added after the fact by historians. They were line items in a court budget, approved by the same administrative process that approved any other civic expenditure. The reasoning behind the clothing was deliberate. By dressing the sow in human garments, the court was making a statement that the broader community could witness and understand. This animal had acted as a moral agent acts. It had made a choice, or so the law held, that resulted in the death of a child. And it would be punished not merely as livestock is disposed of, but as a moral agent is punished, with the full weight of public justice, dressed in the clothes of the civilization whose order it had violated. The execution took place in the town square. The crowd attended. The municipal accounts were filed. The case was closed. And what strikes hardest, reading those records today, is not the strangeness of the punishment. It is the ordinariness of the paperwork. The gloves and the jacket appear in the budget alongside the cost of grain and the maintenance of roads. There is no indication that anyone who approved these expenses found them unusual. Because they were not unusual. This was the law doing exactly what the law was designed to do. The sow of Falaise was not the first pig to be executed by a French court. She was not the last. Cases of swine standing trial for attacks on humans appear in the French legal record as early as 1266 and as late as the early 18th century. But no case is as meticulously documented, and none has left behind as clear a picture of what it looked like when the medieval legal system turned its full attention on an animal and found it guilty. Because someone filed the expense report, someone approved the gloves, someone wrote it down. And the writing survives. The scope of it. It would be easy at this point to treat the trial of the Pig of Falaise as an aberration, a strange local custom, the decision of one eccentric court in one corner of medieval France. But the historical record does not allow for that comfort. Animal trials were not regional. They were not rare. They were conducted across the full breadth of medieval and early modern Europe by courts operating under entirely different legal traditions: civil courts, ecclesiastical courts, church tribunals, and they reached consistent conclusions because they were working from a consistent underlying philosophy. And they involved lawyers, not reluctant participants, not officials forced by circumstance to play act at legality. Trained, ambitious, professionally serious lawyers who saw these cases as opportunities to establish precedent, to demonstrate their mastery of procedure, to build the kind of reputation that advanced a legal career. In one documented case, a defense lawyer had a conviction overturned because the original summons had been improperly issued. The defendant was a pig. The lawyer filed the appeal with the same precision he would have brought to any criminal matter. And won. The most famous of these lawyers argued a case in Burgundy in 1522. His name was Bartholomew Chassanet, and the case he argued did not involve a pig. It involved rats. Case 2, the rats of Saint-Julien, 1522. The city of Autun sits in the Burgundy region of eastern France, surrounded by agricultural land that, in the 16th century, produced barley as its primary crop. In 1522, that barley was in crisis. A population of field rats had established itself across multiple farming areas around the city, and over the course of the season had systematically destroyed crops across a significant portion of the local farmland. The destruction was severe enough that the affected farmers brought a formal complaint before the ecclesiastical court of Autun, the church court, which held jurisdiction over matters involving disruptions to the natural and divine order. The rats were to be summoned to appear before the court and answer for what they had done. Not killed, not trapped, formally summoned by legal writ to present themselves before a judge and respond to the charges against them. The court appointed a defense lawyer to represent their interests. That lawyer was Bartholomew Chassanet. Chassanet was, at this point in his career, a young lawyer working to establish his reputation. He was trained in the full tradition of French civil and ecclesiastical law. He understood procedure with exceptional precision, and when he was assigned to defend the rats of Autun, he appears to have made a decision that would define his early career. He decided to win. On the first appointed court date, the rats did not appear. Chassanet rose to address the court. He argued that the summons issued to his clients was defective. The writ, he explained, had been read in certain parishes in the Autun region, but the rat population in question was not confined to those parishes. The defendants were distributed across a much wider area. Many of them had never received proper notice of the proceedings. Under the established principles of legal procedure, he argued, a summons that does not reach the defendant cannot compel that defendant's appearance. The court had not fulfilled its basic obligation to notify the parties it was seeking to hold accountable. The hearing could not proceed on this basis. The court considered the argument. The court agreed. A new summons was ordered. This time, it was to be read aloud from the pulpits of every parish church in the relevant region, a far broader notification, specifically designed to ensure that no rat in the area could claim ignorance of the proceedings. The summons was issued, the date was set, the parishes were notified. On the second appointed date, the rats again did not appear. Chassanet rose again. He acknowledged that the summons had now been properly served. He acknowledged that his clients had received notice. But he introduced a new argument, one that was, depending on your perspective, either a stroke of legal genius or the most remarkable thing ever said in a courtroom. His clients, he explained, faced a serious practical problem. The roads between where the rats lived and where the court was located were patrolled by cats. This was not a metaphor. He meant it literally. The countryside between the rat population and the courthouse contained cats, the natural predators of his clients. To require the rats to travel to court through territory occupied by their predators was, he argued, to require them to risk their lives simply in order to exercise their legal right to appear and defend themselves. No defendant, he contended, could be compelled to place themselves in mortal danger in order to comply with a court summons. The law recognized the right of defendants to personal safety. It could not simultaneously demand appearance and expose those defendants to certain death on the journey. Therefore, he concluded, His client's non-appearance was legally justified, and the court could not hold them in default unless it first guaranteed their safe passage to and from the proceedings. The court took the argument seriously. It considered the question of whether it could guarantee the cats would not harm the rats in transit. It concluded, apparently after genuine deliberation, that it could not. The case was adjourned without a verdict. The rats of Autun were never convicted. They were never sentenced. They went free, technically, procedurally, legally free, because their lawyer found a gap in the process and drove a wagon through it. Chassaignet's performance in this case was not forgotten. Legal commentators of the period noted his arguments as examples of sophisticated procedural reasoning: the right to proper notification, the right to safe passage, the obligation of the court to ensure defendants could actually comply with its orders. These were not arguments invented for rats. They were arguments drawn from the existing body of legal principle, and Chassaigne deployed them in a case involving rats because the logic applied, and because he intended to use every tool available to him. He went on to become one of the most distinguished legal scholars in France. He was eventually appointed first president of the Parliament of Provence, one of the highest judicial positions in the country. He wrote legal texts that remained in use for generations. His career was built in part on a case he argued for rats. History does not record whether the barley farmers ever recovered their losses. It does not record what happened to the rats either. But somewhere in the archives of the Ecclesiastical Court of Autun, the case file sits with no verdict entered. Because Bartholomew Chassaigne made sure there was none. The lawyers who shaped the law. There is something important embedded in the Chassaigne case that goes beyond the strangeness of the facts. The legal arguments he made, proper notification of defendants, the impossibility of demanding compliance under conditions of mortal danger, the distinction between collective accusation and individual guilt, did not stay in the rat trial. They migrated. The principles Chassaigne articulated in defending a population of rats were picked up by later legal scholars. They were cited in cases involving human defendants. They were refined, extended, and written into the developing body of European criminal procedure. Some of the foundational protections that defendants in human criminal courts enjoy today, protections that most people in the modern world consider obvious and non-negotiable, were first articulated clearly, first argued publicly, in courts where the defendants could not speak for themselves. Where the defendants were animals, the animals almost always lost. The law became more precise because of the arguments made to defend them. That is the particular cruelty at the heart of this history. The courts were wrong about what they were judging, but the process of being wrong, rigorously, professionally, procedurally wrong, produced something that turned out to matter enormously. The third case in our record is different from the first two. It does not involve a single animal or a single violent event. It involves an infestation, a village, a theological argument that a court could not resolve for 4 decades, and a land settlement that we do not know the outcome of, because the final page of the document is missing. Case 3, the Weevils of Saint-Julien, 1545 and 1587. The village of Saint-Julien de Maurienne sits in the Savoy region of what is now southeastern France, in an area of valleys and hillsides that, in the 16th century, was given over primarily to vineyards. Wine was not simply a product in this region. It was the economic foundation of the community. The vines were tended across generations. The vintage each year determined whether families were comfortable or hungry. In 1545, the vines began to fail. The cause was identified as an infestation of weevils, small beetles that attacked the root systems and foliage of the vines, working their way methodically through the vineyards and leaving destruction in their wake. The damage spread. The growers grew desperate. They brought a formal complaint to the ecclesiastical court. The weevils were to be put on trial. A defense lawyer was appointed. The prosecution prepared its case, and what followed was not a quick proceeding. It was a theological argument so complex and so genuinely unresolvable under the legal philosophy of the time that it consumed the court for decades. The prosecution's case was, on the surface, straightforward. The weevils had damaged the property of the villagers. They had disrupted the divine order of the community. The court should decree their banishment or invoke religious authority to drive them away or find some other means by which the law could enforce the rights of the vine dressers. The defense offered a response that the court could not easily dismiss. The weevils, the defense argued, were creatures of God. They had been placed on earth as part of the divine creation, just as the vines had been placed on earth, just as the people of Saint-Julien had been placed on earth. They had not been created without purpose. They had not arrived in the vineyards without reason. They were fulfilling the function for which God had designed them, eating, surviving, reproducing, in the habitat that God's creation had provided for them. If the court ordered the weevils destroyed or driven out for doing what God had designed them to do, the defense asked, was it not passing judgment on God's own creation? Was it not claiming that God had made an error, had designed creatures whose very existence violated the divine order? This was not a frivolous argument in 1545. It was a serious theological problem, and the court knew it. The case was adjourned. It was not resumed for 41 years. 41 years during which the vines presumably continued to suffer, the villagers continued to struggle, and the legal question of the weevils' culpability remained technically unresolved on the ecclesiastical court's docket. When the case was reconvened in 1587, a new generation of lawyers argued before a new judge. The original complaint was now more than 4 decades old. The specific weevils who had first been charged were, of course, long dead, but the infestation continued, and the court treated the matter as an ongoing legal proceeding rather than starting again from the beginning. After reviewing the arguments on both sides, the human right to property and livelihood, the weevils' right to exist according to their nature, the court arrived at a verdict unlike anything else in the historical record. It offered the weevils a settlement. A specific piece of land was identified, a plot outside the village boundary, described in the court documents by its location and dimensions, that was deemed suitable for the weevils' habitation. The land was fertile. It was positioned away from the vineyards. It was, in the court's estimation, a reasonable alternative to the vines. The court's proposal was this: if the weevils relocated to this land and ceased their destruction of the vineyards, the matter would be considered resolved. The community would not pursue further legal action. The weevils would be, in effect, granted a territorial accommodation in exchange for leaving the village's livelihood alone. The court document describing this settlement is detailed and precise. The land is described, the reasoning is explained, the terms are set out clearly. And then the document ends. The final pages, the pages that would have recorded whether the weevils accepted the terms, whether the settlement was implemented, whether the vineyards recovered, are missing. Lost to time, to damp, to the ordinary entropy that consumes archives over 5 centuries. We do not know what happened. We know only that a court of law, presided over by trained legal professionals, operating within the established procedures of ecclesiastical jurisprudence, offered a land settlement to an insect. And meant it. And wrote it down. And that someone kept the document for 500 years. What these courts believed they were protecting. The animal trial tradition in Europe did not end dramatically. It did not collapse under the weight of a single definitive refutation. It dissolved slowly as the philosophical foundations that sustained it were replaced by something new. The Enlightenment, the broad intellectual movement that reshaped European thought in the 17th and 18th centuries, rebuilt the theory of law on a different foundation. Reason, not divine order. Human rights, not cosmic hierarchy. The law in this new understanding existed to protect persons, and personhood was a quality that only human beings possessed. Animals in this framework could not be guilty, could not be innocent, could not be defendants. The very idea became not just outdated but incoherent. The last documented animal trial in Europe is typically cited as occurring in Switzerland in 1906. A dog accused of participating in a robbery in which a man was killed. The dog was convicted as an accessory, sentenced to death. 9 centuries after the first recorded animal prosecution. 200 cases, across 9 countries, filed in archives that range from crumbling parish records to formally preserved legal libraries. The question these cases leave behind is not the obvious one. The obvious question, were they right to do this? Answers itself. They were not right, the courts were wrong, the legal philosophy was wrong. But that is the least interesting thing about these cases. The more interesting question is, what did they believe they were doing when they thought they were right? Because the lawyers who argued these cases believed they were practicing justice. The judges who presided believed they were upholding order. The communities that gathered to watch the executions believed they were witnessing the law function as it was supposed to function. They were protecting something real, the stability of their communities, the sense that there were rules governing how the world worked, and that those rules applied to everything, not just to the powerful, not just to human beings, but to all of creation. They were wrong about the mechanism. They were wrong about the scope of legal personhood. They were wrong about what the law could reach and what it could not. But the fear underneath those errors was not irrational. Every legal system that has ever existed has been built on a version of the same fear. The fear that without law, without something that applies universally, that holds everything accountable, that does not make exceptions, the world slides into disorder that cannot be recovered from. The medieval courts believed that fear was so serious that the law had to reach the pigs and the rats and the weevils. They were wrong about that. They were not wrong about the fear. The Pig of Falaise was executed in gloves and a jacket because someone believed the law could not afford to look the other way. Not even for an animal, not even once. The rats of Autun went free because a lawyer took seriously the idea that the process matters as much as the outcome. That justice conducted sloppily is not justice at all. The weevils of Saint-Julien were offered land because a judge decided that a negotiated resolution, however strange, was preferable to a punishment that could not be enforced. None of these courts was confused about what it was doing. They were all, in their own way, trying to make the law mean something. These are not stories of a world that had lost its mind. They are stories of a world that took the law so seriously it could not imagine anything standing outside of it. Every society since has had to decide where to draw that line. These ones drew it around everything. Clothes. This wasn't myth. It was law.